I'm not sure about that.
Well, let's get it right. I thought. He has a conviction.
There's two. There's an assault to third degree from September 11th of 2019 in the indictment, and then a prior one, attempted robbery, third degree, March 28th, 2013.
Yeah, I was looking at the unlawful possession of a firearm indictment. I don't know that both of those are priors were included in that particular.
No, it's not. It's not, Judge. It's just as one of them in that case. I looked at.
But if there are two, I mean, you would
Right.
file that
I would,
notice, so it would be considered habitual,
Yeah.
correct? Okay,
Eventually I will.
okay. All right, so are you Kendrick Ovil?
Yes, ma'am.
And Mr. Ovil, in cause number 25 DCCR 1776. Sorry, it's taking. You are charged with evading arrest or detention with previous conviction, and that's from August 31st of 2025. That shows that you were previously convicted of evading arrest or detention July 22nd of 2011. So that's what makes it a state jail felony. Then the indictment further alleges you were convicted of attempted robbery, a third degree felony, March 28th of 2013. And after that was final, you were convicted of assault, a third degree felony, September 11th of 2019. And so what that means in that case is that if you go to trial and you're found guilty, and those prior convictions are true, the range of punishment would be enhanced to a second degree felony, which is between 2 years and up to 20 years. Do you understand?
Yeah.
And then in cause number 25 DCCR 1777, you're charged with unlawful possession of a firearm by felon. And that is from August 31st of 2025. That indictment alleges one prior felony conviction, the one from 2019, but the state can file, and I anticipate they would file a notice of enhancement because that 2013 was left off of that indictment. And so what that means in that case is if you're found guilty and if those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years in prison, up to 99 years or the rest of your life. Do you understand? And then finally, in cause number 25 DCCR 1778. Once we get all these done. You're charged with a third degree felony offense of deadly conduct, discharging a firearm from that same date of August 31st of 2025. It does allege those two prior felony convictions. Again, what that means, if you're found guilty and if those prior convictions are true, you would be considered a habitual offender in that case also, with a minimum punishment of 25 years, up to 99 years or life in prison. Do you understand?
Yes, ma'am.
In all of those cases, I have here on this tablet a plea bargain rejection in each case that you've signed with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty in your cases, to go on, probably it looks like counts 1 and 2 for a 15-year term instead of that habitual. And so in 2 of the cases, a 15-year term, and then in
It's 15 on all, concurrent on all of them, Judge. Yeah, because it's state jail is it.
oh, I opened the wrong one. Sorry. Hold on, y'all don't want me to do that. That's a 30.
Oh, that's my next one.
Sorry. Okay, so 15 years in all 3 cases that would run concurrently, which means together at the same time. Do you understand what the state has offered you?
Yeah.
And so you have every right to reject that offer and have all 3 of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty in your cases. And do you understand all of that?
Yeah.
And do you want to reject those offers and have your cases set for trial? All right, we'll get that done. I do want to, is there any reason to believe that these offers would change?
Not at all, Judge.
So, Mr. Ovil, I want to make sure you understand that after today, unless there is new evidence that is discovered by either your attorney or the state's attorney, I will not accept these plea agreements again. Once it's on the trial docket, it either goes to trial, you can plea open to the court or to some different amount or negotiated punishment. Do you understand? Okay, so I will get your cases set for trial. Mr. Ovil, Mr. Parker has been appointed to represent you. He's one of the case attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you? Okay, so Mr. Parker, you're released. Mr. Ovil, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Thank you.
Thank you. Good morning, you're John Dre Willis. And so we were here before for sentencing. Mr. Willis had pled guilty to burglary of a habitation. There was a question about whether or not there was a murder charge pending or coming over in Calcasieu Parish. Charles? Lafayette, sorry. And so what did you guys find out?
Okay, so I spoke with the detective out there. He referred to the prosecutor. Prosecutor said that there is a co-defendant. His case was sent to the grand jury. The grand jury, they don't call it no bill out there. I don't know what they call it. They no billed him on the murder, but they sent in a suggestion for manslaughter. So
On the
co-defendant.
Okay,
So the prosecutor told me that it's possible that Mr. Willis' case may go to the grand jury as a manslaughter, but he doesn't know yet. And he said they don't know until Mr. Willis gets to Louisiana. So there hasn't been anything filed on him.
okay.
Judge, I left a message for same District Attorney Chris Landry on February 24th after we recessed from our last docket. I called back and spoke with his assistant who was going to give him another message. And I made multiple attempts yesterday to reach him and wasn't able to reach anybody at that number where I had previously reached them. So I made every attempt I could to let him know. I filled in his paralegal about the situation we had and said, hey, heads up, if you guys want to hold or you need a 10-day marker or something, it'll be from next Tuesday, meaning today. So
Right.
those are the efforts I made. And I would suggest that out of fairness to the defendant, we, if the court is inclined, we go along with the original plea of deferred. If
Sure.
they want to use it later, I'm happy to share my files information with them, but I don't think we should punish him with a conviction for something just because that may or may not be out there.
All right, I agree.
And also, Judge, I'm sorry.
Sure.
Just so that the court can recall, this is the one where the complainant went back and forth on wanting to prosecute. She did not. She came to court. She got a little jittery. She changed her mind. She waffled back and forth a few times, which was the reason for it all.
Okay, thank you, Ms. Malvino. And thank you, Ms. Holmes, for making those calls as well. Okay, so what I'll do, Mr. Willis, today is go ahead and go forward with sentencing just the way this was all set up. If something happens when you get over to Lafayette and you're indicted or convicted, obviously we'll know where you are. If you, as soon as you're released, if they get a hold on you and take you straight from here, then when you are released, the first thing you need to do is contact our probation office.
Okay.
So whenever that is, all right? And if for some reason there's a conviction over there for something and you get some type of prison time, then you can write Ms. Holmes or get in touch with her or the court, and there's probably can take care of this at the same time so that you're not doing some time and also on probation. Okay, but we'll deal with that when and if it happens. All right, so then in cause number 25, DCCR 1048, I'm going to find that you, and we've already gone over the pre-sentence report and everything. So I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You ordered to pay the $300 fine and to follow all of the rules and conditions of probation. If you do that, then this is an excellent opportunity, especially if nothing comes out of whatever happened over in Lafayette, because you do not have a felony conviction on your record. And if you successfully complete this probation, at the end, the case is dismissed. You'll never have the felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you could be found guilty. So you would become a convicted felon and you could be sent to prison for anywhere in that range of punishment which is between 2 years and up to 20 years in prison. Do you understand? And I'm assuming there is a no contact,
Colette Richard.
what's the name?
Colette Richard.
Colette Richard. And so you're not to have any contact or communication with Colette Richard. And I understand that she's gone back and forth and y'all have gone back and forth. But unless you have my permission, which could happen if you get out and you're on probation and you're doing well, and she probably takes an options class or something like that. If y'all are planning some type of relationship, you're not, so we don't have to talk about that. Then don't contact or communicate her. If she tries to contact or communicate with you, don't reply, okay? Because she won't go to prison, you will, right? All right, so I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to